Today's program will provide a summary of relevant vaccine mandates, including the Biden administration's mandate for large employers and the CMS mandate. We will also discuss requiring vaccination for employers as a matter of policy within your practice. This is our fifth webinar that we've held in collaboration with the law firm Paley Rothman since the start of the pandemic. We really appreciate their partnership. And so we would like to thank our speaker, Jessica Summers Esquire, who's the principal in the firm's employee benefits, employment law, retirement plans, litigation, and government relations practice groups. She works with companies and organizations on establishing and implementing effective employment policies, drafting employment agreements, and maintaining employee benefit plans, addressing corporate planning issues, and monitoring and advising clients on legislative and regulatory developments of import to them. So I'd just like to say welcome, Jessica, and thank you so much for joining us today.
Thanks for having me. Would you like me to start screen sharing? There we go. All right. Hi, everybody, and thanks for joining us today. Let's see if I can get this screen sharing to work. All right, so we all should have the screen up now with the slides. As Krista mentioned, my name is Jessica Summers. I'm an employment law attorney at Paley Rothman. So as you can imagine, we have been up to our necks in vaccine mandates and vaccine questions. So hopefully my goal today is to help parse some of this stuff out for you, answer any questions you might have, and just let you take away a little bit more clarity about all the different mandates we're talking about. I know that the term gets thrown around a lot. There's a lot of acronyms, abbreviations, so it's hard to know exactly what applies to you. So we're going to try to sort of parse that through and give some more clarity today. So just taking you with a bit of an overview, what I'm going to do is we'll go through each of the different requirements, and then I'm going to pause for a moment. So if you have any questions once we finish discussing one of the items, feel free to raise it at that time, and we'll also leave time for questions at the end. So first, we're going to start with the government-issued mandates. So the ones that if you are a covered business, you have to comply with. And then we're going to move over to the question of voluntary mandates. So elective mandates that businesses that may not be captured by any of these government-issued mandates, elective mandates that these businesses have decided that they want to implement. So let's kick off with Maryland. Maryland, there is an order in place in Maryland that applies to nursing homes and hospitals. That order was put in place back in August. It went into effect on September 1st of this year, and it requires that all staff who are working in nursing homes or hospitals in Maryland be vaccinated. And staff does include contractors, volunteers, employees who are performing any work at the facility. So if you're a business that is either operating a nursing home or a hospital, or have employees that are being placed or contracted out to these types of entities, it'll be a good idea to check to confirm whether this order is going to apply to you. The requirement is if you are one of these covered businesses or covered employees, these employees need to be vaccinated. So there is no testing option. The baseline requirement here is vaccination for anyone who's working in a nursing home or a hospital in Maryland. Now, the covered facilities do have to have a policy and process for processing reasonable accommodation requests from employees who are not vaccinated because they have a sincerely held religious belief or a disability. We're going to get into those kinds of accommodation discussions a little bit later in the presentation, but important to note that if you are a covered facility in Maryland under this order, you need to have a policy and procedure in place for handling it. And at minimum, Maryland requires that if you do have someone that you're dealing with an accommodation for, at minimum, an unvaccinated person who qualifies for an accommodation does need to submit for testing on a weekly basis if they have an exemption to the mandate of being vaccinated. So moving from Maryland to the federal level is where we're seeing sort of more of the movement that's a bit broader. So federal contractors, this is sort of the first mandate we saw going into effect that implicates private sector workforces. So this was an executive order that was issued back in September. There was actually an earlier executive order, and this executive order 14042 replaced that. And this executive order applies to federal contractors and subcontractors. No matter what level of subcontractor you are, if you're on a federal contract, that term has to flow down to you as the subcontractor. And the requirement under this executive order is that all covered employees have to be vaccinated. Again, there is no testing option when it comes to this federal contractor rule. The executive order that predated this did have a testing option for federal contractors. So it's important to understand new federal contractor rule. If you have a federal contract or employees working on a federal contract, the baseline is a mandatory vaccination with no testing option. So talking about who are covered employees to the extent that you have a business with any type of federal contract, covered employees are both going to be the employees who are working on or in connection with that federal contract. So doing anything to support that federal contract. And that includes working directly on the federal contract and doing anything supportive. So your billing people may get captured, accounts payable may get captured, depending on how integral they are in the contract that you're dealing with. Additionally, employees are also going to get captured if they're working in a workspace or a facility where there are employees who are servicing a government contract. So essentially, if you have anyone who's servicing a government contract in your workplace, the entire group of people who are working in that workplace are going to get captured by this vaccine mandate. Now, the requirement has been bumped back a little bit. Originally, the deadline that was set was for December. Now things have been bumped back to comply and to coordinate with this new OSHA requirement that I'm going to talk about in just a moment. So right now, the deadline we're looking at, if you have any federal contracts, the deadline you're looking at is you need folks to be fully vaccinated by January 18th. And fully vaccinated, as we're talking about these concepts, fully vaccinated means that someone is 2 weeks after their last shot, whether it's a 2-shot series and 2 weeks after their second shot, or the 1-shot Johnson & Johnson 2 weeks after that shot. So essentially, in order to meet this deadline, employees need to be getting their final dose of the vaccine by January 4th of 2022. Now, I would note we're not going to dive into requirements outside of the vaccine mandates. We're sort of going to target those today, but I would flag that if you are a federal contractor who is covered by this executive order, you do want to make sure that you're taking a look at the executive order, not just the vaccine mandates, but there are requirements that go beyond just the mandate and deal with health and safety rules that federal contractors have to follow for all vaccinated and unvaccinated employees. So important to note that if we have any federal contractors who are considering this. So I'm going to pause for just a moment, make sure we don't have any questions on the federal contractors or the Maryland rules at this point. Looks like we do not. So we will charge full steam ahead. So the next set of rules, there's sort of 2 sets of rules, got really confusing because they both got dropped on the same day. So November 5th was vaccine mandate day in the federal government, really. So the first one we're going to talk about is the CMS interim final rule. The CMS interim final rule applies to a whole slew of Medicare and Medicaid certified providers. And I've got a list here. I've got a list here of all of the different providers that are covered and the different types of providers that are covered. So to the extent that you are a provider that is certified Medicare and Medicaid, and you have a facility that is one of these on this nice long list, you are going to get captured by the CMS interim final rule. And the CMS interim final rule does not have a sunset date at this time. So it's going to be in effect until CMS says otherwise. Now, what does that final rule require? The final rule requires that all covered employees must be fully vaccinated. Again, there's no testing alternative option here. We saw testing alternatives, and we will see testing alternatives when we talk about the OSHA rule. When we're talking about the CMS rule, if you are covered by the CMS rule as a business, there's no testing alternative for your general lay employees. Covered employees are going to be any employee who works at a covered facility, unless the employee is 100% remote. So if you have someone who's working mostly remote, but may come into the facility occasionally or have contact with other employees occasionally, that person is going to be covered by this rule. And as I said, the rule is that employees must be vaccinated. So we're looking at a timeline with full vaccination by January 4th. Is the requirement. So essentially that means that the first dose needs to be administered by December 5th, 2021. Now, CMS has said they will give some flexibility. So as long as someone has their second dose by January 4th, 2022, as long as they have that second dose, even if they're not finished with their 2-week window, it won't be considered a strict violation for an employee to be coming and working, even if they haven't gotten through that 2-week window, as long as they have both shots by January 4th, 2022, CMS will accept that. Now, same with the federal contractor rules, there are provisions for accommodations to be requested. Now, the CMS rules, we're still waiting on a little bit more guidance and clarity, because the CMS rules specifically refer to accommodations that are requested in accordance with federal law. They don't deal with accommodations that may be requested out of state law. So it's a little bit interesting. But as a general rule, both under state and federal law, so Maryland we're dealing with here, federal law, there is an obligation to accommodate employees, again, who can't get vaccinated because of a disability or because of a sincerely held religious belief. So we need to make sure, if we are a CMS covered entity, that we're dealing with those accommodation requests and we're communicating with employees to make those accommodation requests. Under the CMS interim final rule, all accommodation requests should be due by December 5th. So for a business that is covered by the CMS interim final rules, it is imperative that that process start now to communicate with employees that A, they need to get vaccinated unless they qualify for an accommodation, and they need to start that process by December 5th if they've not done so already, and B, that they need to start a process of submitting an accommodation request no later than December 5th if they have a reason for not being vaccinated. It's important to note, when we're talking about these vaccine mandates, these vaccine requirements, employers do need to go ahead and start collecting the information, the verification from their employees to show that they're vaccinated. Under most of these rules, it's not going to be enough just to take an employee's word for it. You want to get the white card, you want to get a medical record that shows that an employee has been vaccinated, and you want to hang on to that, because that is showing compliance with the rules in case CMS, OFCCP, or OSHA came knocking on your door. Depending on what rule you're covered by, you want to make sure that you have that documentation to show. Now, as medical providers may be more aware than some of my other clients that I work with, it's important that the information related to an employee's vaccine status, request for accommodation, or any other medical information does not go in the personnel file. Any medical information, whether it's dealing with vaccine mandates or a doctor's note for someone for some other reason, any medical information needs to be kept in a separate confidential file apart from the personnel file. And we see a lot of confusion, complication with that sometimes, and a lot of businesses getting that wrong and just shoving the information into the personnel file. Really, the logic here is that the personnel file is something that perhaps a manager needs to see, or someone who's working with the person needs to see. And the individual who's doing that and taking a look at the personnel file should not be getting medical information that they have no need to know when they're going into an employee's personnel file, which is why we keep the medical information separate and kept on a need-to-know basis. And then the personnel file can be more broadly available to someone who in a management level needs to know that information, but may not need to know that an employee suffering from a certain disability has requested an accommodation, has a reason for not being vaccinated. An additional note, when you're collecting the vaccine information, you really want to make sure that employees are not providing you with additional medical information that you as an employer do not want to know. Generally, ignorance is bliss when it comes to employment law. If you don't know about someone's protected category or someone's protected situation, you can't be subject to a claim of discrimination on that basis. So, for example, if someone gave you their full printout from their physical saying, you know, the employee got vaccinated, but the employee is also suffering from XYZ conditions, you don't want to know that, because now you have a documented record that the business knows that an employee is suffering from XYZ conditions, and, you know, something happens down the line, you might see a claim from that employee saying, well, you know, they terminated me because they knew from the medical record I submitted to certify my COVID vaccine status that I was also undergoing testing for potential cancer, and that's why they terminated me. So making sure that if you're accepting something other than just the white cards from the employees, that you're telling employees, we don't want to know any medical information that is not related to the vaccine status, and you should redact any information from the documents you're providing. Safest and easiest course of action is just to take the white cards. But some employees may have lost their white cards, need to produce other information. So if you're getting other information from employees, making sure that you're careful with that. And I would note that, with the CMS rules, before we move on, there are penalties for failing to comply. For the federal contractors, the most serious penalty for a federal contractor is that you lose your federal contract. For the CMS rules, there are civil money penalties that can be imposed for a business that violates. There is also the chance to lose that Medicare and Medicaid partnership. So ensuring compliance as close to the rule as possible is going to be critically important. We're going to move from the CMS rule, so I'm going to take a moment just to check the chat to make sure we don't have any questions. So we've got a question: are clinics or private practice office with physical therapy components subject to this, or just physical therapists employed within these clinics? For example, orthopedics at PM&R and ENT services who have PT services. So I'm assuming that you're referring to the slide we were just at here. It's going to depend on whether the facility is a Medicare or Medicaid certified provider. If the facility is a Medicare or Medicaid certified provider, it is going to be anyone who is working in that facility that is going to be covered by these rules. Hopefully that answers the question. So now we're going to jump over to, we got one more, hold on. So what vulnerability does an employer risk if they fire an employee for failure to comply? As far as failure to comply with the CMS standard, there's really no vulnerability that the employer is facing because it is a government mandate. The only time you run into problems is if you terminate an employee after an accommodation request. So with the CMS rules, with the OSHA rules, we're lucky in Maryland to some extent that we aren't in a state where there are conflicting state rules that are butting heads with federal rules. In a number of jurisdictions, employers are really being caught in the middle between the federal government and the state rules because you have states rolling out these provisions saying you can't require vaccines, employers can't require vaccines, and then you have CMS issuing this interim final rule saying you as a business must require vaccines. Typically, the general rule of thumb is federal preempts state law, but we still are seeing litigation coming to a head as these conflicting rules are sort of parsed out. In Maryland, we don't have that problem. In Maryland, employers are free, as we'll talk about in just a moment, are free to issue vaccine mandates, whether voluntarily or in compliance with the federal contractor rules, the CMS rules, the OSHA rules, whichever apply to them. And basically, if an employer is covered by one of these rules and doesn't issue the vaccine mandate, so take, for example, the CMS interim final rule, if you do not require an employee who does not qualify for an exemption to be vaccinated, then you're running a pretty serious risk of a potential fine, a potential complaint. So really, there is no alternative but to separate an employee who is not willing to comply with the rule. I know that is a real challenge, particularly in the medical field where staffing shortages are significant. And I've been seeing a number of my clients in the medical field saying, we're going to wait to implement this rule as late as possible, or we're going to try to do what we can because we're concerned that we have people who are going to walk and that we're going to have trouble with staffing when we implement this final rule. But really, it's hard because there's not an alternative for employers here. And part of the logic with the CMS rule and the OSHA rule and a number of these federal rules being rolled out at the same time from the administration's perspective was, let's basically, if we're going to roll out these requirements, let's roll them out at the same time so that the options for an individual who is not vaccinated and does not qualify for an exemption, the options for them to leave an employer that's subject to a rule and go elsewhere are going to be more limited because different workforces are going to be subject to different vaccine rules. The hope was to control some of the flow, but I believe between people leaving for one job that might be covered by a rule to another one that is not covered by a rule. The idea was to get as many businesses covered by these rules as possible. So as I mentioned, the only place that you could run into a potential problem, we'll dig in just a few minutes to the questions of accommodation, reasonable accommodation of employees with disability, sincerely held religious beliefs. That's where we see potential problems if you terminate an employee. If you terminate an employee because they have they've not been vaccinated who might qualify for an accommodation, you don't handle that accommodation request process properly, that's where you can see a problem and potential liability as it relates to complying with these rules. But beyond that, just for the folks who are subject to these rules and have no exceptions, there is going to be no consequence for the employer. There shouldn't be any consequence for the employer of complying with these rules. Of course, you can never protect against frivolous lawsuits, but those would be tossed out pretty quickly, as there would be really no basis since the employer is complying with a government mandate. So we're going to turn next to the OSHA Emergency Temporary Standard. And I want to be clear, we're talking here about the Emergency Temporary Standard that was issued on November 5th. OSHA already issued a different Emergency Temporary Standard, as many of you I'm sure are familiar with, dealing with healthcare workplaces back in May. Safety standards, a whole slew of provisions that I'm sure you are all intimately familiar with by this point. What we're talking about here is a new OSHA Emergency Temporary Standard that applies broadly beyond just the medical sphere. And this Emergency Temporary Standard arose from, in September, basically, the president rolled out his pathway out of the pandemic plan, directed OSHA to take action to issue this Emergency Temporary Standard to try to increase the vaccination rates. Now, all of the Emergency Temporary Standards, the way it works as far as OSHA's authority, OSHA has the authority to issue an Emergency Temporary Standard if they determine that there's an immediate hazard in the workplace that is imposing on employees that an Emergency Temporary Standard can be used to remedy. So basically, OSHA needs to justify the fact that we can't wait and go through the standard notice and comment rulemaking process to issue this rule. We need to do this now. We need to move quickly and do this now. In issuing the Emergency Temporary Standard, unlike the CMS rules, the Emergency Temporary Standard does have a sunset. The Emergency Temporary Standard is only going to be in effect for 6 months or until a final rule is issued. And OSHA did start the process, the regulatory process, to issue a final rule that would replace this Emergency Temporary Standard and supplant it. So it may be that this gets replaced before that 6-month sunset. That's usually the course of action that they take. Now, in issuing the Emergency Temporary Standard, as I said, they started the process to issue a final rule. So what that means is that OSHA, contemporaneously with issuing the standard, which will go into effect, will apply to the individuals identified in the standard. OSHA is also seeking notice and comment about what a final rule might look like. So the final rule that ultimately comes out of the process may not be the same as the Emergency Temporary Standard. In particular, OSHA has left the door open to extend a final rule to smaller employers than the ones that are covered by the current Emergency Temporary Standard. So if you're a business that is not covered by the current Emergency Temporary Standard, I would certainly urge you not to just sort of stick your head in the sand and assume that it doesn't apply to you when you see anything that comes out of OSHA, making sure you're staying attuned, because there may be a final rule coming down the line that would impact you. Now, I would note that as we're diving into the OSHA Emergency Temporary Standard, OSHA basically has made it clear that they're not trying to step on anybody's toes here. So as we talked about, the federal contractor rule and the CMS rule both require vaccines for employees unless they qualify for an accommodation. OSHA has made it clear that basically if a workplace is subject to the CMS rules, if a workplace is subject to the federal contractor rules, this OSHA requirement, the OSHA ETS, is not going to interfere with that. It's not going to change the rules or pile on top. So we have employees who are subject to the federal contractor rule. That's what's going to apply. We have a workplace that's subject to the CMS rules. That's what's going to apply. OSHA temporary standard is basically coming in to capture anybody who might otherwise be covered, who is not covered by one of those other rules. So the OSHA Emergency Temporary Standard, which I'm going to refer to just for simplicity's sake as the ETS is going to apply to employers with 100 or more employees. Now, as we're counting employees, it's important to understand that we are counting temporary employees, we are counting part-time employees, we are counting seasonal employees, and we're counting remote employees. So anyone who's on your payroll as W-2 is going to count towards that 100 number. If you're a business that right now you're on the threshold of 100, or perhaps during certain seasons, you increase the number of people you have just because of the demand from your patients or from your business partners, if you have a situation where you go over that 100 employee threshold while this emergency temporary standard is in effect, you are going to need to be in compliance with the ETS. So any business that's currently at 100 or any business that in the next 6 months kicks over that 100 employee level is going to be covered by the emergency temporary standard. Now, as far as the vaccine requirements that are contained in the emergency temporary standard, there are sort of two key dates. The first is December 5th. December 5th of this year, covered employers, so the employers with 100 or more employees, need to go through and identify the vaccination status of all of their covered employees. So this is something that, December 5th is coming pretty quickly. So this is a process that for businesses that haven't already identified their employees' vaccine status, this is something that we definitely recommend starting if you're potentially going to be covered by the OSHA emergency temporary standard. And then the next deadline is that by January 4th, 2022, covered employees must either be vaccinated or submit to testing at least once a week. The only exception to this, the only employees for a business with 100 or more employees that get out of this rule are employees who work exclusively from home, so they never come in the workplace, employees who work in a workplace where they are the only person there. So, one of the good examples we're seeing out in the industry is truck drivers. Truck drivers who just get in their cab, drive the truck, and that is their workplace, or individuals who work in a single office. I don't think there's going to be a whole lot of folks from what I'm seeing in the medical field who would fall into that category. And then employees who work exclusively outdoors. Again, probably not relevant for many of your practices, but the employees who work exclusively from home may be relevant. For folks who work almost exclusively from home, so they sometimes come into the office, you don't have to require them if they're not vaccinated. You do need to ascertain their vaccination status. But if they're not vaccinated, you don't have to require them to submit to testing once a week if they're not going to be in the office at least once a week. So if you have someone, for example, who works exclusively from home but comes in once a month for a meeting, you simply need to get that employee to submit a test within 7 days of when they're actually going to be entering the office. So that gives you some leeway so that the employee isn't having to get tested during weeks when they're working exclusively from home. Now, we're not going to dive into it today just in the interest of time, but I would flag that the ETS also includes safety standards and reporting requirements. So dealing with reporting COVID cases in the workplace, dealing with policies that employers need to have about excluding employees who have COVID symptoms, and masking and other safety policies for unvaccinated employees. All of those are contained in the ETS. So important to recognize that if the ETS is going to apply to your business, and I'll get to the why I'm saying if in just a moment, but if the ETS is going to apply, that's something else that employers need to be mindful of. And there are significant penalties for violating an OSHA rule. These are the same penalties that we see for any other OSHA violation that can really get up into the tens of thousands of dollars for single violations. So really important to make sure that you're sticking in compliance. So why the big if? There is a exciting sort of legal challenges occurring now. And for anyone who is a law nerd like me, it's been really interesting to watch and gets into a lot of the procedure. So essentially the ETS on the vaccine mandate, the one we're talking about now, was previewed on November 4th. It was issued formally on November 5th. And within 24 hours, there was already dozens of cases coming in challenging the ETS. And there's a few different ways that this is being challenged, a few different sort of postures the lawsuits are taking. One is basically challenging whether or not OSHA has the authority to issue a rule like this at all. So whether this needs to be an act of Congress, or whether OSHA, whether through an ETS or through a final rule, has the authority to issue a vaccine mandate like that. Then there's also a set of cases that are challenging whether an ETS was justified. So whether there was a sufficient hazard at this time, now that we're a year and a half into the pandemic, whether there's a sufficient hazard to merit the OSHA issuing an ETS instead of going through the normal notice and comment rulemaking process in order to issue this. So we've seen dozens of cases. This is actually now more than 6 different circuits. We're now almost to the full slew of all the circuits have received cases. challenging. On November 6th, the Fifth Circuit, that had received one of the earliest cases challenging this rule, issued a temporary injunction. Temporary injunction basically means they are staying the rule from going into effect on a nationwide basis until they decide the case in the challenge. So it essentially maintains the status quo while the court can deal with the issue. There was some back and forth and some filings from the government, filings from the petitioners who are challenging the rule. Fifth Circuit reconsidered and decided on November 15th, yes, we're going to keep this injunction in place for the duration of while we consider this case and prevent the rule from going into effect. Well, the Fifth Circuit took this action, but the Fifth Circuit really is not going to be necessarily going to be the deciding voice on this. What happens when you have a single rule being challenged in a bunch of different jurisdictions, a bunch of different circuit courts, is that there's a process, because the federal circuit court system want to have an outcome where you have 25 different cases being held by all the different circuit courts, and have a situation where you have the Fifth Circuit deciding, the Ninth Circuit deciding another way. They want to make sure that there is consistency across the circuits. So what they do when there is a case like this, or a situation like this, where you have multiple challenges to the same issue, the same rule, is they essentially hold a lottery. And it's, as I was describing to Carissa before we started, it's literally a wooden drum that they put the names of all the circuits that have a case in the drum. It's only one per circuit, so it doesn't matter how many cases have been filed in that circuit, but they put the name of the Fifth Circuit, the DC Circuit. They put the name of the circuit in the drum, and they pick it out. And that will be the court that is going to decide all of the cases. And that lottery is actually happening today. It's scheduled to happen today. It hasn't happened yet. I just checked before we got on. But that is going to decide which of the courts is going to handle all of the challenges. So once a court gets assigned, they get to reconsider anything that has happened in any of the cases up to this point. So a court that gets assigned will get to look and say, we are going to lift the temporary injunction issued by the Fifth Circuit, or we're going to sustain the temporary injunction issued by the Fifth Circuit. So it'll be sort of a wait and see moment to find out which court is going to get this case. And it's been really interesting. It's going to be basically, it really could be any court that gets this, because originally we were seeing most of the cases being filed in the more conservative jurisdictions. And then we started seeing what are essentially dummy cases being filed in some of the more liberal circuits in order to get those liberal circuits into the lottery. So essentially groups that actually support the regulation and that actually support the ETS were filing litigation challenging the ETS, but they were filing it in the Ninth Circuit up in California or in the DC Circuit, just to make sure that those courts have a chance to consider the case. So it's not simply the more conservative jurisdiction. So it really is going to be a lottery to figure out where this case is going, where these cases are going. Will be really interesting. And of course, if the Fifth Circuit is the one that gets selected in the lottery today, we know where it's going. We know that there's going to be an injunction that's in place, meaning the rule will not go into effect on December 5th, most likely, because the court is going to be considering the case going forward and issue a temporary injunction while having that consideration. Now, no matter what path we take and what court gets it, there is a very good chance that we're going to end up at the Supreme Court with this case. So we're just sort of waiting to see the direction that it's going to go. But it really is a developing situation. So the challenge for businesses is that December 5th is coming up soon, as is January 4th, particularly if you have employees who are unvaccinated that need to plan and time it out, because it takes 5 to 6 weeks to become fully vaccinated. So we are encouraging businesses to not take a wait and see approach on this, to at least start taking a few steps to make sure that they understand the rule, understand whether it applies to them, and then really think through what the obligations are going to be if the rule goes into effect, just so that they're prepared. It is better to be prepared than be sorry and confused later. So one of the big things, beyond but ancillary to the vaccine requirement in the OSHA ETS that I want to make sure folks are aware of, assuming and in the event that the rule goes into effect on December 5th, is leave requirements. These are going into effect December 5th. So if there is no temporary injunction on December 5th, this rule will go into effect and these requirements will go into effect. So the ETS requires employers to provide employees with up to 4 hours of paid leave to receive each dose of the COVID vaccine. Now, if an employee gets the vaccine outside of regular working hours, the employer doesn't have to pay for that. If the vaccine takes less time because there is a CVS next door or because it's being administered in the facility and being administered by the employer, it's the same situation. You don't have to pay employees for more time that it actually takes them to get vaccinated. It's just to make sure here that employees are not suffering from having their leave used up or having to take unpaid time to get vaccinated. Now, if you have employees that are provided with PTO, sick leave, you can't deduct from their balance for the time that they're taking to get vaccinated. So making sure that you're basically giving employees up to 4 free hours of paid leave in addition to anything else you might provide them if they need to get vaccinated. Additionally, there's also a requirement in the ETS that employers provide employees with a reasonable amount of paid sick time to recover from side effects. As far as what a reasonable amount of paid time is, generally OSHA is saying in their FAQs 2 days. So in this situation, you can require employees to use their sick leave or their PTO that they would have available for sick time if they have to be out because of side effects from the vaccination. But if they don't have leave time, you can't require them to draw a negative balance, and you do need to provide them with extra leave time if they don't have enough leave time to take up to 2 days if they have side effects from the vaccine. And just one more, sort of one more section of the OSHA ETS that is sort of ancillary to the vaccine requirements is the testing rules, and just a little bit more on the testing rules. So if you have a situation where you as an employer has decided that you're going to allow a testing option, and I say you're decided you're going to allow a testing option, because that's not required under the OSHA ETS. Under the OSHA ETS, the way they have it structured is basically they encourage employers to issue a vaccine mandate and require all employees except for those who qualify for an accommodation to get vaccinated. However, the ETS does allow employers the option of alternatively requiring employees to get vaccinated or submit to testing. So it's up to the employer which channel you want to take here. Now, for the testing requirements, if you're allowing a testing requirement, again, it's like the vaccine requirement in that you need to maintain a record of employee test results. And again, that needs to be maintained separate and apart from the personnel file. But if OSHA comes knocking on the door, if these rules go into effect, it's going to be critically important that any business that has elected to allow employees a testing option is maintaining a record of the test results. Under the ETS, employers are not required to pay for the cost of testing or to provide paid time for testing. However, we're still waiting on guidance from the EEOC as to whether that may be not true for individuals for whom testing is their only option. So if you have someone who can't or won't get vaccinated because of a protected reason, so a disability or a sincerely held religious belief, we're waiting for the EEOC to say whether or not employers can pass the cost of that testing, the time for that testing, off to that employee. But we clear under the ETS itself that for anybody who doesn't qualify for an accommodation or doesn't have other protections under the law that would require the employer to pay for their time or the cost of testing, the ETS does not impose that requirement on the employer. We'll take just a moment because we're going to move to the next section, but to take just a moment to make sure we don't have any questions. So I'll get into the question on serious side effects in just a moment. And I think we already addressed the question on paying. OSHA ETS is not required, but what about Maryland law? Maryland law, well, it's going to be a matter of, Maryland law has been largely deferring as far as the accommodation requirements have been largely deferring to what the EEOC is saying. So if the EEOC says you have to pay for testing for someone who needs an accommodation, that is going to likely flow down with Maryland law, but there is no separate Maryland law that says you have to pay for testing. So we'll talk about exemptions in just a moment for the person who just answered that question. we do not have any sense as to whether and if the EOC will come out with recommendations to the person who asked that question. The EOC has been regularly updating their FAQs, but there is no directive or instruction for the EEOC to issue this. EEOC does not have to take instruction or direction from OSHA, but there is sort of this gap because the way that OSHA's ETS is phrased is, we as OSHA aren't imposing this requirement, but somebody else might. So that's where there's a little bit of a hole because EEOC has not yet dealt with a scenario where vaccines are required as opposed to where vaccine mandates are permitted. All right, so moving to our next sort of top topic, and we talked about the planning ahead. Moving to our next top topics, the next question we get is from businesses that say, okay, I'm not a federal contractor, I'm not a hospital or nursing home in Maryland, I'm not covered by the CMS rules, I have less than 100 employees, where does that put me in the state of Maryland? And the answer is, it's really going to be up to the business what you decide to do. The real question is, can we require employees to get vaccinated if we're not covered by any of these federal requirements that is going to mandate that we do this? And the answer is yes. Subject to important caveats and considerations that we're going to talk about in just a moment on accommodations. Yes, under federal law, you can require an employee to get vaccinated as a condition of their employment. Under state law, it depends. As I said, there are some states that are adopting and enacting rules that prohibit employers from mandating vaccines, prohibit employers from asking employees about their vaccine status, but none of the DMV jurisdictions have adopted such a rule. So we don't have that coming into play, which is extremely helpful. So diving into reasonable accommodations, because this is sort of the big sticking point we're seeing many businesses face. So there's sort of two types of reasonable accommodations. One is under Title VII and state laws that require accommodations of religion and sincerely held religious beliefs. And the other is under the Americans with Disabilities Act and state laws that require accommodations of individuals with disabilities. Now, first, talking about accommodation of individuals with disabilities, employers that are choosing to mandate a vaccine or employers that under any of these prior rules we've been talking about is required to mandate a vaccine do have an obligation to issue a reasonable accommodation to an employee who can't receive the vaccine because of a disability. This could be a short-term disability or a long-term disability, a medical situation. So, perhaps you have someone who is recently recovered from COVID and their doctor says, because of that, they can't get vaccinated right away. Perhaps you have someone who's newly pregnant in a high-risk pregnancy and their doctor says they can't get vaccinated right away. It might be a short-term situation or it may be a long-term situation. We've seen clients that have had people who are allergic to the vaccine and got one shot, couldn't get the second shot, or simply had a doctor recommend against them getting any of the shots. So it really is going to be a matter of making sure that if you have a vaccine mandate in place, you're leaving that opening for employees with disabilities to come to you and request an accommodation. Now, what's that accommodation going to look like? It's tough, and it really depends on the workplace. Unvaccinated employees, even from the workplace, if the employer can show that essentially there's no reasonable accommodation that can be offered because there is a significant risk of substantial harm to health and safety simply by virtue of having an unvaccinated employee on staff and in the building. So we've seen, some of the medical practices that are working with high-risk patients taking this approach and taking the position that, it would create a substantial risk to health and safety to have an unvaccinated person around, someone who is immunocompromised. So they have taken the position that for health and safety, there is no reasonable accommodation that would allow someone who's unvaccinated to be in their workspace. Even if you can show that there is a significant risk to health and safety, you still have to consider other reasonable accommodations that might be offered to the employee. So perhaps that is, working from home or working in an isolated area where you're not exposed to patients. So it's necessary for the business to engage in what's called the interactive process to sort of look at all options and determine, is there a reasonable accommodation that exists? So is there something that's not going to pose a risk to health and safety that is going to allow the employee to do the essential functions of their job? We don't have to create a whole new job for them. It's still needing to do the essential functions of their job without being vaccinated. And then the next big question, or the next threshold is is that going to pose an undue hardship on the business? Now, the threshold for undue hardship for rejecting or deciding that there's no appropriate accommodation for an individual with a disability is much higher than it is for an individual who's requesting a religious accommodation. For an individual with a disability, you really need to show a very high level of burden or cost on the employer to justify a position that it is an undue hardship for the employer to offer a reasonable accommodation if there is an accommodation that exists. Now, frankly, what we're seeing, in the field is that reasonable accommodations of disabilities is not where employers are having challenges. The disability situations tend to be fewer and farther between and a little bit more clear cut and easier to confirm and discern. Where we're seeing employers run into a lot of headaches is with respect to religious accommodations. So employers that have a vaccine mandate, whether voluntarily or out of one of these rules we've talked about today, if these employers are obligated to accommodate an employee's sincerely held religious belief unless doing so poses an undue hardship. And I would note that it's important to understand that the sincerely held religious belief doesn't necessarily have to be aligned with what the senior level clergy or the leadership in a church has been saying. So, for example, we've seen a growing number of religious accommodation requests from Catholics who are opposed to abortion and opposed to the use of stem cells, objecting to the fact that all of the vaccines currently offered in the United States were tested, at least in some way, using stem cells. The Pope has not raised any concerns with vaccines. The Catholic leadership has not raised any concerns with vaccines, save for the Johnson & Johnson. There were some because there was actually stem cells used in the development of the vaccines, not just the testing of it. But these individuals still can assert a sincerely held religious belief because it is based on their tenets of their faith, even if it is not based on the leadership that they're getting from their church or a tenet of their church. Now, with the sincerely held religious beliefs, it's hard for the employer sometimes to parse them out. When are we seeing a political belief or a personal belief versus a religious belief? So we really need to be focusing on whether the employee's objection to a vaccine mandate is arising from a religious tenet. So, or whether it is simply, someone we've seen, one recently that was, I live a clean lifestyle. I don't believe in putting chemicals or anything foreign in my body. If it's not based on a religious belief, that's a personal belief and is not going to be subject to protection. The EEOC has basically taken the position that where an employee asserts that they have a sincerely held religious belief, the EEOC has basically said that employers really shouldn't be in the business of challenging whether that religious belief is sincerely held unless there is reason to believe that someone is not being truthful. So, if you have someone who, just last year requested leave for a religious holiday for one religion and is now asserting a different religion, maybe you question that a little bit and you dig into that a little bit to confirm that they actually have converted a sincerely held religious belief. But if someone just comes out and says, this is my religious belief, we have no reason to question that. Typically, we don't want to be in the business of challenging whether a religious belief is sincerely held. So the next question is there a reasonable accommodation that can be offered that wouldn't pose an undue hardship? And it's a similar kind of interactive process as you go through with dealing with accommodation requests for employees with disabilities. Again, if the objection to the vaccine is that they object to the entire all the vaccines, so there's no vaccine that they can get, there may be a situation where there's no accommodation that would allow them to work in the workplace because it's not a reasonable accommodation to have someone in the workplace when it poses a risk to health and safety, just as we discussed with the disability accommodations. Now, as I said, with the religious accommodations, if we identify a reasonable accommodation, so say some kind of alternative that allows the individual to be unvaccinated, the threshold for Title VII and when a religious accommodation can be denied on the basis of an undue hardship is much lower than it is for when it can be denied on the basis of a disability. So for religious accommodations, a religious accommodation can be denied if it imposes an undue hardship. An undue hardship for religious accommodations means that it imposes more than a de minimis burden or cost on the employer. So it is a fairly low threshold there. So we do see more than in the case of disabilities, where it's a much higher threshold of what constitutes an undue burden. It really needs to be a high cost or burden on the employer. A more than de minimis burden, we do see situations where employers are saying, that's too difficult logistically, that's too costly for us to be imposing safety measures for someone, and perhaps is rejecting a religious accommodation. But it is a very delicate area when you're dealing with any of these accommodations, and I would certainly encourage folks not to go it alone, because we are seeing a serious increase in cases and claims that are stemming not from just the base vaccine mandates, but are stemming from failure to properly handle accommodation requests and to properly document exactly what's happening. So if there's a determination that no reasonable accommodation exists, there needs to be documented evidence and analysis of that. If there's a determination that any accommodation that exists poses an undue hardship, there needs to be documentation of that. It's important that the employer has a trail. So making sure that we aren't in a situation where there's a vaccine mandate, whether voluntary or government issued, and employees are told, well, if you're not vaccinated, we can't do anything for you, and not taking those steps to engage in an interactive process. Even if we know that the likely outcome is going to be there's no option for this person, we still need to engage in that exercise. So a few additional points of caution when dealing with vaccine mandates, whether voluntary or involuntary. The first is being sure to be careful to prevent harassment or retaliation against employees who've gotten an accommodation. So making sure to the extent possible that information is kept on a need-to-know basis, but also to ensure, for example, if you have someone who can't get vaccinated because of a disability, they can do their work from home. So you're allowing them to do their work from home, making sure that their manager understands that they can't retaliate against that person because they resent that person is working from home, whereas other people in that same position are working in the office. We need to be really careful that those people who we've given an accommodation to are being treating as equally as possible. We can't be perfect. Perhaps there's, lost opportunities of just the in-person networking and interactions, but making sure that people aren't being actively harassed or retaliated against because they've gotten an accommodation. I've talked about protecting the medical information, so vaccine cards, accommodation documents, testing, making sure those are in a separate file and kept locked up. Thinking about the potential issues related to adverse vaccine reactions. I got a question on this earlier, and it's a hard question of what is going to happen. That's what employers are asking me. What is going to happen if I tell an employee they have to get vaccinated, they go get vaccinated and have a really bad adverse reaction? Well, OSHA, before they issued the ETF, actually, OSHA came out and basically said, at least for the time being, they are not going to consider an employee who has an adverse reaction to a vaccine that is required by their employee to have suffered a workplace injury or illness that needs to be reported to OSHA. So they basically excused employers from having to report that. So that sets aside the OSHA side of things. Now, there may be an issue with workers' comp. We're just starting to see this issue developing, so there's no perfect answer to see what the workers' comp claims are going to, what the outcome of these workers' comp claims are going to be. But we started to see workers' comp claims from certain people who have experienced adverse vaccine reactions, and basically take the position, this is a workplace illness or injury because you required me to get this. So they filed workers' comp claims, and those are still working out. And then as far as sort of a general liability issue, generally the courts do, and the law does favor employers who are taking reasonable steps that are permitted and clearly permitted and endorsed by the government at multiple levels, but that are in the interest of health and safety. However, what we don't have right now in any of the jurisdictions around here are any type of liability shields. There was a push really early on in COVID to create liability shields for businesses. So, protect businesses from claims from employees who are working that got COVID, even if the employer was following reasonable safety steps. Protection against claims by employees who have adverse reactions to vaccines that are required. We haven't seen any sort of strict protections for employers at this time, so it's still an evolving issue. But I would say that from what we're seeing, I think that it may be it may be more a sense of concern for the employer than it's actually going to actually be a risk, just given the sort of few and far between cases of someone suffering a really serious adverse vaccine reaction, doubled up with the fact that this is clearly being promoted as an important public health and safety policy. I think that ultimately an employer, even if challenged, is going to come out ahead on this. And then I would flag that, don't let your guard down and continue to comply with best practices and safety requirements. So, if you're covered by the earlier OSHA ETS, the safety ETS, any state and local rules, that are outside the scope of our presentation today, making sure that, just because you're going ahead and complying with CMS rules or complying with the OSHA rules, the new OSHA rules, that you aren't forgetting those safety measures that might still be required to be in place. So with that concludes the sort of substance. Sorry, I'm skipping ahead. One more slide. The vaccine mandate policies. For those people who do not have a policy in effect yet, a few things that I'm seeing that are gaps in people's policies that I would sort of suggest as you're crafting. And I know that that you've had information shared with you of some sample policies available through SHRM. But things to look at when you're developing a vaccine policy, both if you have a mandate in place from the federal government or if you have a requirement that you're imposing yourself. Educating employees about when the mandate is going to go into effect so that they understand when they're going to have to be in compliance and can plan ahead. Explaining what constitutes vaccinated. So if you have a hard deadline like some of these rules have, making sure that employees understand, you need to start the vaccine process because fully vaccinated means 2 weeks after the last shot. So making sure you're planning in advance. Definitely including a reasonable accommodation statement with information for employees about how they can request that reasonable accommodation. Informing employees what documentation they have to provide and to whom, and making sure that if that documentation is more than just the white cards, you are telling employees, do not give us any medical records and information that does not cover just your vaccine status. And then reminding employees and educating employees about the safety rules and procedures that still remain in effect, making sure that vaccine policies and requirements are rolled out as not a substitute to the safety policies, but in conjunction with the safety policies, and then making sure that there's clear reservation of rights to change the policy at any time going forward. Making sure it's clear to employees, yes, we're trying to comply with OSHA, we're trying to comply with CMS, we're telling you need to get vaccinated now, but if things change, we could change our position on that. So making sure that that's clear to employees. So with that, false alarm the first time, but now happy to take any questions, and it looks like we have a few.
All right. Yes, we do. So we've got one from Dr. Green who asks, in evaluating religious belief, can you ask if the employee takes Tylenol or Advil, both of which used fetal tissue in their development?
Yeah, that's a great question. Actually, an approach that one of the hospitals in Texas made news for taking. This hospital had a number of employees that were coming out and requesting a religious accommodation based on the fetal tissue being used in the development or the testing of these vaccines. And so the hospital's reaction was they gave employees a long list of all the common medications and drugs and things that had been developed using that fetal tissue, and asked the employees to certify that they do not use any of those items. And from at least from the reporting, it sounded like that was successful in getting certain employees to step back and realize that their religious belief may not have been as sincere and strictly held as it had been. But I would certainly talk to an employee who comes to you with that concern. If someone is saying, if we're seeing copy and paste jobs, I guess, for lack of a better word, we're seeing people who are, looking for a way, in many instances, looking for an avenue to object to, are being coached. And there's plenty of websites out there that have information about, how to assert this objection. So we're seeing, medical and scientific and chemical citations that you wouldn't normally expect from an employee. So certainly having a conversation with the employee about whether it is sort of a sincerely held religious belief. If they're asserting something along those lines that seems to conflict with other behavior, it would not be inappropriate.
Okay, and then we have another question with regards to what qualifies as a federal contractor, asking if medical practices who participate in Medicare or Medicaid, if they could technically be considered a contractor of the federal government.
So if you participate in Medicare or Medicaid, most likely I would expect that you're actually going to be captured under the CMS rules. A federal contractor is someone who either has a direct contract with the federal government or is a subcontractor of someone who has entered into a direct contract with the federal government. So, for example, if you are a business, a contractor, I've seen a couple of these who supply doctors or nurses for prisons or for the VA or medical facilities, and you're a private entity, that would be a situation where you'd be a federal contractor that would be covered. If you don't actually have a direct contract with the federal government, but you're simply accepting money through federal government programs, more likely you're going to find yourself in that CMS bucket.
Okay, thank you so much. I think that's the last question that I see. If you do have one more question for us, go ahead and drop it in the chat now. But with that, I will go ahead and just provide a couple of reminders to our attendees. Thank you all so much for joining us today. We will make this webinar available online via our YouTube channel. So don't forget to subscribe to our channel for other additional content, including webinars on telemedicine, remote patient monitoring, and provider relief fund reporting. I also did want to just put on your radar that MedChi continues to coordinate all clinician calls with Dr. Howard Haft of the Maryland Department of Health on COVID-19. The schedule is once every other week, so Wednesdays at 5 p.m. To register for a call, visit montgomerymedicine.org. And then MCMS has a COVID-19 vaccine toolkit with all the latest resources on booster shots, so please visit us online to access that. And then finally, on December 2nd at 1 p.m., we will have a former inspector from the Maryland Occupational Safety and Health Administration join us for a session on OSHA with all relevant updates. And so, of course, he'll talk about both of the OSHA ETSs, which may apply to your practice there as well. So with that, I would just like to thank you all for joining us and thank our speaker, Jessica, once again for a wonderful session this afternoon.